There's some seats right here on the front row. Come on in. I am really grateful to be here today and to introduce Professor McCormack. As you've all read his bio, you know his expertise. He is a very unique position in that he is the special advisor on law of armed conflict issues or international humanitarian law issues to the prosecutor of the ICC. And that, of course, means that he has to be one of the best experts in the world on these topics, and I can vouch for you clearly that he is, and that you will really enjoy his remarks. He has had a long history of interaction with the law of armed conflict, with laws in military situations. In fact, his great-great-grandfather, have I got enough greats in there, Tim? His great-great-grandfather was had a number of run-ins while he was in the Irish military, and was eventually sent to Tasmania as a convict. And that started now the genetic connection with the McCormacks and international humanitarian law. They beat up officers in the law, they're insubordinate, they don't do the right thing, and so he would probably be prosecuting his great-great-grandfather if he was still alive today. What I would like to say about Professor McCormack is that he is, of course, not only a genius, but a wonderful lecturer. And I would encourage you to ask him questions, hard questions, and to take this opportunity to really delve into his knowledge on this issue. Professor McCormack.
Thank you. Thanks for coming. It's really great to have you here today, and I'm honoured and privileged to be able to come down to BYU. I'm with my family, or at least part of my family, two of my three children, and my wife at the US Naval War College in Newport, Rhode Island, on sabbatical from the University of Melbourne for 11 months. And it's really terrific to come to Utah for the first time in my life. Let me just say, in relation to the world map, I love world maps, and I'm really glad that this one's so sizable. But Tasmania, where I come from, where my great-great-grandfather was transported to, is the island to the south of the mainland of Australia. Down there, sort of on a par with the southern island of New Zealand. And we claim, where I come from, that the air on the west coast of Tasmania is the purest in the world. And I want you to just verify it with me, because look at 42 degrees south latitude. On the west coast, I've got a very good friend of mine from high school with a fishing shack there. We go and dive for lobster and abalone and other things during our summer. We look out on his deck to the great Southern Ocean, and you go 2/3 of the way around the world under the Cape of Good Hope to the east coast of Argentina before you reach landfall. It's just all ocean. Purest air in the world. Come on down sometime and check it out for yourself. In Australia, the joke is that Tasmania's tiny, but it's bigger than Florida, and I worked out if you lined up all the states of the Union, Tasmania would come in at number 23. So that's irrelevant, of course, to today's subject matter. It's just that Madeline was thanking God for our blessings, and one of mine is to have grown up in a place like that. What to do with terrorists? What an incredible topic. We chose this topic, Professor Jensen and I, in consultation some time ago, long before the Paris terrorist attacks. And all of a sudden, the topic seems to be incredibly propitious in terms of timing for all the wrong reasons, not all the right reasons. I'm not excited about the coincidence of timing. It's terrible, of course, for 130 people to have lost their lives in Paris, and in the days afterwards for a whole lot more to have lost their lives in Bamako in Mali, in Kabul, in Beirut, all attacks that ISIS has claimed responsibility for. Imagine if you were the president of France, President Hollande, right now. 130 French people blown up in the capital of that great state, and there is, as a consequence, prodigious political and popular pressure on the president to not only prevent other attacks, but to be seen by the population to be undertaking substantive measures in response. So as a consequence of those attacks, France closed all its borders. That's not an easy thing to do because it shares a number of land borders. So what that meant was that... Sure. I'm not sure what that. No, I'm joking. I can't. I have to be careful. I used to react negatively to cell phones going off, but then one day I left mine on and it went off during one of my own talks. So never again will I criticise, because it can happen to all of us. So what that meant was roadblocks on all the major roads into France, closure of all the airports and all flights in and out. The declaration of martial law, which enabled French police to raid hundreds and hundreds of homes without warrant. This, of course, raises a big dilemma for us, doesn't it, about where is the correct balance between protection of personal liberties and protection of the population from a potential future attack. And then, of course, French airstrikes on ISIS targets in Syria, which were significantly ramped up as a consequence of the attacks in Paris. You'll all remember, no doubt, 9/11 and the Bush administration's responses to that attack on US continental territory. Several days later, or about a month, 4 weeks later, the US and coalition allies commenced a bombing campaign in Afghanistan because the Taliban, then exercising governmental authority in Afghanistan, were harbouring al-Qaeda and refused to hand over Osama bin Laden to the US. The United Nations Security Council, within days of the 9/11 attacks, came out in support of the US and reaffirming the right of self-defence to prevent future attacks. And many countries in the world, my own, but not only those countries who'd lost nationals, particularly in the attack on the Twin Towers of the World Trade Center in New York, but many countries from around the world were sympathetic to the US. The Bush administration response involved the rounding up of thousands of detainees in a sort of massive net in the hope of catching some of the bad guys, and that also created a massive dilemma of what to do with these people. As we think about what to do with terrorists, then the question for the French government is if they actually capture any of the individuals responsible for the Paris attacks or supporting those who were. This is also true for the Belgian government, what to do with them. There are several popular suggestions, none of which I plan to defend today, but just bomb them and the suburbs that they're in. I think Donald Trump's suggesting that's what we do with ISIS right now in his presidential nominee campaign, to just line them up and shoot them, or to incarcerate them and to torture them or undertake whatever interrogation techniques we need to be able to extract intelligence information from them. The bottom line for me today is that if we gain custody of any of these individuals, we need to try them. And we need to try them in a fair and open and transparent trial process that satisfies minimum international standards. If we don't do that, it seems to me that the terrorists have succeeded in dragging us down to their own level. And if we genuinely believe in our way of life as superior to theirs, and there is a clash of worldviews with ISIS, then one of the key ways to demonstrate that our way of life is superior is to demonstrate that through fair trial process. I'm happy to take questions about my opening statement in relation to that in due course, but I really want to try and ensure that I don't rave on too much, that I speak for about 30 minutes and we have plenty of time for question and answers. So let me move to Guantanamo Bay, military commissions, civilian courts, international courts or tribunals as alternative fora for the conduct of a fair, open and transparent trial. And I'll start with military commissions. They're the first named in the list of those three options. Post 9/11, the US Bush administration military commissions have been subjected to a torrent of criticism, not only in the United States domestically, but also internationally in the UN, by NGOs and by many other countries. And I really want to focus on three key criticisms of the commissions. The first of them is a lack of independence. An independent judiciary is fundamental to our notion of the separation of powers. Can you imagine if the governor of a state in the United States could or even rich and influential people could just ring up the Chief Justice or the DA and say, please don't bring charges against this individual because they're a mate of mine, or they've contributed to my election campaign, or whatever other reason we would want them not to be the subject of proceedings. We call that corruption, and we despise it when we see it. I have to say, I know all about it because I've been living in Rhode Island for 4 months. And there's a lot of talk about corruption in that state. But those appointed to the Military Commission, I think, lacked independence, and I want to try and explain a little bit about that. I had some experience with the military commissions by being asked by the US Marine Colonel who was appointed to defend an Australian detainee in Guantanamo Bay, David Hicks, to join his defence team and provide some legal advice on law of war aspects of the case. This guy, David Hicks, was the first person to be subjected to military commission proceedings, and his experience was, I think, indicative of what I would describe as a fundamental lack of independence of the military commissions. Ironically, David Hicks benefited from the lack of independence, and let me explain a little bit about how that happened. The chief military prosecutor, Colonel Morris Davis, US Air Force officer, was instructed by the convening authority, the person appointed by the White House to run the military commissions, to bring forward the proceedings against David Hicks. And that was all about satisfying some political demands on the part of the Australian government, who had described Hicks for years as one of the 20 most dangerous people in the world, who wanted him back in Australia before our next federal election with a conviction as a terrorist. David Hicks had been held in detention in Guantanamo Bay for 5 years and 1 month before proceedings were brought against him, and for over 3 years before charges were ever laid. Colonel Davis was told to expedite the proceedings against Hicks, and we know that that was the case because he subsequently admitted that that's what happened. In fact, a plea arrangement was done between David Hicks's lawyers and the convening authority without the prosecutor's knowledge and awareness. And as a consequence of that plea arrangement, David Hicks agreed to plead guilty to the charge of providing material support to a terrorist organisation. He'd trained with the Taliban and with Al-Qaeda in both Pakistan and in Afghanistan. And he received a sentence of 9 months in detention and then suspended for 6 years and 3 months subsequently. So a 7-year sentence, 9 of it to serve in prison. When that plea arrangement was announced, Colonel Davis had no idea about it. He conceded in the press conference after the proceedings were all over that under the rules of the military commissions it was possible for Major Maury, the US Marine lawyer defending David Hicks, to do a deal with the convening authority, but the prosecutor had absolutely no input into it. In fact, what happened, as we understand also from the disclosure of individual accounts, is that Vice President Cheney, on a visit to Australia, was asked by Prime Minister Howard at the time to get David Hicks back to Australia convicted. Prime Minister Howard says he then called President Bush and pleaded with him to please make this happen, and so Colonel Davis was told to bring the case as soon as you possibly can. This is not the hallmarks of an independent system, and unfortunately we now know a lot more about that. Colonel Davis, after the Hicks proceedings, where he was devastated at the outcome, having said for months that he was asking for 20 years as a sentence for Hicks, was posted out of the position and then came back as a witness for the defence team in a subsequent proceedings and testified to the Military Commission that the system was fundamentally flawed for its lack of independence. The second and I'm really happy to talk about this. I'm just trying to provide a bit of an overview, make sure I get through the material in time. But please, if you want to ask me tough questions or easy questions or any other sorts of questions, you go for it, okay? I'll welcome it. Second basis of criticism is the illegality of subject matter jurisdiction. The military commissions were ostensibly established to try violations of the laws of war. Unfortunately, in my view, the Bush administration attempted to expand the subject matter jurisdiction beyond violations of the laws of war by adding extra offences to try to cast the jurisdictional net significantly further than the laws of war. So, for example, under the original military instructions that established the commissions and then subsequently the Military Commissions Act of 2005 and the revised or amended Act of 2009, there were 2 charges of murder, for example, that the military commissions could try. The first of those was murder of a person protected under the laws of war, so the murder of a prisoner of war, the murder of a wounded or sick or shipwrecked combatant, the murder of a civilian. And I can assure you that that war crime is thoroughly uncontroversial. No one has a problem with the inclusion of the war crime of murder of a protected person under the subject matter jurisdiction of the military commissions. The problem was an additional charge of murder, which was murder in violation of the laws of war. And that offence, or the elements of that offence, were for an unlawful or unprivileged combatant to have killed an opposing military member. Now, unfortunately, this is not a violation of the laws of war. It doesn't mean that it can't be a domestic criminal offence, an offence under the national law of the United States, but it's certainly not a violation of the laws of war. David Hicks, in the initial charges that were laid against him, was charged with the offence of attempted murder in violation of the laws of war. That charge was all about taking up arms against the United States and other allied countries, including Australia. We could have tried him for treason or some other offences under our own military law, perhaps, but never had the opportunity to do that. This, I think, was a really problematic aspect of the military commissions, and we've seen how problematic it has become. I'm only giving you this one example of murder in violation of the laws of war, but another of those is also providing material support to a terrorist organisation, the very offence that David Hicks ended up pleading guilty to. The Military Commission's appeals panel has recently, in a separate proceeding brought by another individual accused of the same offence, dismissed that as a valid crime within the subject matter jurisdiction of the US Military Commission. So now David Hicks, I imagine, will commence proceedings possibly against both the US and the Australian governments for the fact that he was detained for 5 years and convicted of an offence that isn't an offence. It's problematic. The third basis of criticism is in relation to the rules of evidence and procedure. And here, let me just explain several aspects of the rules of evidence and procedure which combined have hugely deleterious impact on our basic understanding of minimum standards of fair trial. First of all, the Military Commissions Act, both versions, 2005 and 2009, specify that evidence obtained by torture is inadmissible before military commission proceedings. On its face, that's comforting. But you probably will all know that torture was redefined. And there are a number of pieces of legislation. It's a labyrinthine process to get to the definition, but torture was redefined to mean not the infliction of severe physical or mental pain or suffering as defined in the 1984 UN Convention Against Torture, to which the US is a party, but to mean the severe infliction of physical pain resulting in death, maiming, the loss of an organ or of bodily function. And everything else beyond that serious threshold, everything below that serious threshold, I should say, is coercion. And under the rules of the Military Commission, the rules of evidence and procedure, evidence obtained by coercion short of torture is admissible if it is of probative value to a reasonable person. And the decision maker about that test is the single military judge responsible for the conduct of the Military Commission. Okay, so we have this rule about evidence obtained by torture. We add to that the fact that under the rules of evidence and procedure, witnesses testifying against an accused were not necessarily required to appear in person. The prosecutor could tender written evidence, a statement taken from a witness, but unfortunately, under the rules, the circumstances of the obtaining of that evidence, if it was deemed to be in the interests of national security, did not have to be disclosed. We add to this the definition of coercion and torture, and the lack of a requirement that a witness appears in person. And I admit that, of course, written evidence is often tendered in international criminal proceedings as well as in domestic criminal proceedings, but it's the combination of these things that's really disconcerting. We add to that the third factor, the hearsay rule, and under the rules of evidence and procedure for the military commissions, evidence which was hearsay, so what somebody heard somebody else saying, could be admitted if it had probative value to a reasonable person and was not prejudicial to a fair trial. And again, both tests to be determined by the single military judge. Combine those three things together and you could have, I'm not alleging that it happened, but you could have evidence obtained by interrogation techniques which would constitute torture under the Convention Against Torture but are characterised as coercion, resulting in written evidence of an unknown witness who said he heard something being said about the individual accused, and all of that being used against the particular individual accused with no capacity to test the strength of the evidence. That is a huge problem. And you all understand in terms of domestic criminal law, in terms of Uniform Code of Military Justice and the rules of evidence and procedure that apply to US courts martials, that sort of combination of realities is completely unacceptable. No US national could be tried by the military commissions because of your constitutional right to a fair trial. And I remember Major Maury repeatedly saying to Australian audiences, why do you tolerate your government subjecting one of your nationals to a system that the US will not subject its own nationals to? I have to say here, I'm not opposed to the establishment of military commissions. Please don't misunderstand me. The US has utilised military commissions for a very long period of time, certainly as early as the US Civil War. And they've been used post-World War II in both the Pacific and European theatres of that war. And from my perspective, military commissions as a forum for the conduct of trials are absolutely fine if they conform to fair trial rights, which are consistent with those minimum fair trial rights that in the international community we accept as the minimum standards that apply. Let me move to civilian courts and make some observations about the possibility of trials of terrorist offences before civilian courts. In the United States, there is a very long history of the prosecution of terrorist attacks before your civilian courts, whether those are for terrorist attacks on US territory, including incidents such as the Oklahoma bombing, the first bombing of the World Trade Center towers. Some of you might not even know that happened, but I think it was 1994. A bomb was blown up from a truck that was parked in the subterranean car parks of the World Trade Center towers, and the Boston Marathon bombings. Then, in addition to those terrorist attacks that have occurred on US physical territory, there have also been prosecutions of incidents of terrorist attacks against US targets or against US nationals abroad. One of the very well-known ones is the case of Eunice, who was involved in a number of aircraft hijackings, some of which included US aircraft and many of which included US passengers on board. There was also prosecution in relation to the attack on the Achille Lauro, the Italian cruise liner that resulted in the death of a US national. And there are also examples of US prosecution of terrorist-related offences perpetrated by US nationals in foreign jurisdictions. So the proceedings against John Walker Lind and Jose Padilla, for example, are both indicative of what I'm talking about. These two guys could not be tried by US military commission and were tried by US civilian courts instead. And incidentally, on the subject of David Hicks ironically benefiting from the lack of independence of the US military commissions, the parents of John Walker Lind wondered why their son was sentenced to 20 years imprisonment for the same offence that David Hicks pleaded guilty to and got 9 months for. And I personally have to admit that I can understand their frustrations with that. Under your 18th title of the US Code, your National Criminal Code, Chapter 113B is the chapter that deals with terrorist offences. It includes definitions of both international and domestic terrorism, and most of these cases that I've referred to have been successfully prosecuted under the auspices of that legislation. We've learnt from extensive experience of the prosecution of terrorist offences that civilian courts here in this country are eminently capable of conducting trials for terrorism offences. There's a problem with a number of the detainees at Guantanamo Bay, and Khalid Sheikh Mohammed, or KSM as he's better known, is a really sort of classic example, emblematic example of exactly this problem. You know that Attorney General Holder proposed to try him in New York under federal jurisdiction in the state, or not just the state, the city in which the 9/11 attacks occurred. But that all unravelled in part because the allegations of coercion in the interrogation techniques used against KSM at Guantanamo Bay and elsewhere in US detention create huge problems for the admissibility of much of the evidence against him. And that, I think, is one of the really sad consequences of some of the practices at Guantanamo Bay, as well as the proceedings of military commissions there. What about in relation to international criminal courts and tribunals? Well, I wouldn't have any objection in principle to international criminal courts and tribunals trying terrorist offences, but we have a bit of a problem at the International Criminal Court that I serve because there is no crime of terrorism as such. There was a lot of discussion about the inclusion of the crime of terrorism at the Rome Diplomatic Conference to negotiate the terms of the statute that now regulates the operation of the court, but there was no multilateral agreement on the inclusion of the crime, much less on trying to agree on the definition of the offence. That's problematic. I mean, we could try people for crimes against humanity, for attacks on a civilian population, but the threshold elements of a crime against humanity wouldn't necessarily be easy to satisfy in some terrorist attacks. In some, I think they would be, but in others, probably not. So the statute of the International Criminal Court could be amended to include terrorism, but there seems to me to be no multilateral appetite for that, or no appetite for that amongst the 123 states parties to the institution, to the statute, the Rome Statute, which establishes the court. There is, however, a very interesting example of an ad hoc international criminal tribunal set up to deal with an incident of terrorism. That is a special tribunal for Lebanon, which was established by the UN Security Council to deal with the accountability of individuals allegedly responsible for the assassination of Prime Minister Rafik Hariri of Lebanon, undertaken, it's now alleged, by Hezbollah personnel in Beirut. The reality is that this ad hoc tribunal was established after the Rome Statute had entered into force. The Rome Statute specifies that the ICC only has jurisdiction for crimes occurring subsequent to entry into force on the 1st of July 2002. The assassination of Rafik Hariri certainly happened after that date. But still, the Security Council decided, rather than refer the situation involving that incident, which was a car bombing in Beirut that resulted in the death of I think it was nearly 70 people, including Hariri himself, that they would establish this ad hoc tribunal, also based in The Hague, but in a separate building, even separate suburb, quite distinct from the ICC. I'm not exactly sure why the Security Council chose to do it that way. I suspect it might have had something to do with the lack of a definition of the crime of terrorism in the ICC statute, and a question about whether the threshold elements for a crime against humanity might have been satisfied in the context of the Hariri assassination. Single one-off car bombing, obviously devastating in its scale and consequences, but perhaps not a widespread or systematic attack on the civilian population of Beirut. The Special Tribunal of Lebanon is well underway with its first trial of alleged perpetrators. Ayash and others, AYYASH is the surname, the last name of the first named defendant. But that is a trial in absentia, and under other international courts and tribunals jurisdiction, there is no capacity for trials in absentia. Special Tribunal for Lebanon includes it because in Lebanese law that is a possibility, Lebanese domestic criminal law. Interestingly, in the Special Tribunal for Lebanon, the definition of terrorism comes from domestic Lebanese criminal law, and perhaps that's one of the advantages of an internationalised or hybrid tribunal like this one that draws on both international and domestic legal sources. Let me just try to conclude in a few minutes and then open the floor to questions. Terrorist attacks are an abomination, aren't they? Imagine if they were to occur in your neighbourhood, in quiet little virtually crime-free Provo or Melbourne or wherever we happen to live. When our favourite cafe or our favourite theatre or whatever it is happens to be the place where somebody blows themselves up to kill as many people as possible. There should be accountability for despicable crimes like this, but my argument is that it should be fair, it should be transparent, it should be impartial, and it should be independent. I'm going to do something that I would never do in a secular institution and just finish off with a theological response. Briefly, I'm not a professor of theology. This is sort of personal reflections. But it's occurred to me as I've reflected on my time here that if we can open with prayer, we can end with a few reflections on theological responses to what we're talking about. Let me just think about 4 events in our understanding of the biblical account: creation, the fall, redemption, and judgment, and apply it to the problem of terrorism and how to deal with them. First of all, creation. We believe, don't we, that all of us, and not only us, but everybody else in the world, every other human being, was created at the pinnacle of the created order, alone in the image of God himself. Can we find it in ourselves, if we truly believe the theology of that, to agree with the sovereign ruler of the universe about not ISIS victims only, but also ISIS perpetrators? These too are my children. Can we do that? That's a tough one, isn't it? But that is the truth of that theological proposition. Secondly, the fall. We as believers ought not be surprised by the darkness in the world that is represented in terrorism, not only in terrorism, of course, but it is a stark representation of one of the consequences of sin entering in the world, into the world. And as believers, we ought not be surprised by that, even though we are constantly surprised and devastated by accounts of what's happened. Then we come to redemption. We say, we believe, and I'm not challenging that we do, the sufficiency of Christ's redeeming sacrifice, that it is sufficient for all the sin in all of time, including every single terrorist attack. Well, That is an incredible truth. But if we say we believe it, then we must accept that the significance of the sacrifice of the Son of God covers all of that. And then God's judgment. This is a great comfort to an international criminal prosecutor, if they happen to believe it. I remember reflecting on the truth of what we believe about God's final judgment during the Milosevic trial, when I sat as amicus curiae on international law issues to the judges, and time again would listen to Mr. Milosevic cross-examining prosecution witnesses and tearing them apart as he challenged their version of events, as he knew more about their childhood, their background experiences, and the prosecution knew themselves. And I kept thinking to myself, in God's final judgment, none of this will be necessary. The prosecutors won't have to prove every element of the offence beyond reasonable doubt, because that judgment will be final but also perfect. And the statement will be, this is what occurred and here are the consequences that flow from it. If we want efficiency in our criminal jurisdiction, one day we will truly see it. I'm going to finish with that surprising conclusion, I have no doubt, to many of you, and open it up to questions from the floor. Thanks very much.
So we do have some time for questions, and we'd invite them. We just ask you to form a line over at the wireless mic there so we can record for our podcasts and audio online. Tell us your name, what you're studying, and please go ahead. We have about 10 minutes for questions.
My name's Kevin Huffner. I'm a student of international relations. First of all, thank you for sharing some really personal thoughts related to theology. We love that. I love that. My question is just about the ICC. One of the criticisms of the ICC is that it unfairly or disproportionately targets less powerful nations, typically in Africa.
Yeah.
Does the good outweigh the bad? I don't know. What's your response to that criticism?
Thanks, Kevin. I appreciate that question very much. And between you and I is a map of the continent of Africa, and it's absolutely true that all 8 country situations currently the subject of formal investigation are from Africa. Now, there are several responses to that, and I've heard the most impressive one from the current prosecutor, who is a native of the Gambia, right out on the west coast. And she was subjected to the criticism that this is African-centric, and that's prejudicial to the Africans. The African Union, of course, is very unhappy about it. They're talking about establishing a regional international criminal court for Africa. Her response was, there are some good reasons why African cases have been the sole focus so far of formal investigations. And the first of those is that this continent has been racked by devastating conflict. DRC, the Democratic Republic of the Congo alone, 20 million people have been killed there. 5 million people have been killed there in 20 years. The worst, or the most extensive loss of life in a single armed conflict, although there are multiple armed conflicts going on, but in a single country situation since World War II. This is devastating, and it's not limited just to the territory of the DRC. It's a reality that's been replicated across great swathes of African territory. But the reality is that of the 8 formal in-country investigations going on, 4 of those are governments, including the government in Kinshasa in the DRC, Uganda, the Central African Republic, and also Mali, have come to the prosecutor of the International Criminal Court and said, we are incapable of dealing with the justice issues arising out of the conflict that's racked our territory for the last, X years. Please help us. That is exactly what the court was set up to do, is the prosecutor's position. I agree with it. What are we to say to them? No, you're African, so rack off. I mean, no, that's not the way that it works. We're here to assist, especially countries that don't have the capability to undertake the justice processes themselves. an additional 2 of the 8 country situations have come by way of UN Security Council referral, Libya and Sudan, or Darfur, the Darfur region of Sudan. What's the prosecutor to say to the UN Security Council? No. Unless you send Sri Lanka and Syria and a whole lot of other situations as well, we won't take Libya and Sudan. No, that's not for her to decide. The other 2 country situations both come by way of the prosecutor exercising proprio motu powers, that is her own initiative, with the agreement of a pre-trial chamber of 3 judges. They are Kenya and Cote d'Ivoire, and in both cases the countries involved are states parties to the Rome Statute and have consented to the court's jurisdiction. So her position is there are some explanations for why we've been African exclusive or African centric so far. But the fact is that the court was established for the whole of the international community, at least in theory. There are some major limitations to its jurisdiction. The fact that we don't have jurisdiction over Syria is the glaring example of that, and I'm grateful that the US supported the French initiative to try to get UN Security Council referral, but that was vetoed by China and Russia, or perhaps I should say Russia and China in that order, because that's the reality. But we as an institution have to be seen to exist for the rest of the international community as well. And I also think it's a very, very big challenge for us to be seen to be even-handed with allegations of ICC crimes perpetrated by more powerful states. We've had the very first example just a few weeks ago of the prosecutor going to a pre-trial chamber requesting approval to open a formal investigation in Georgia, former republic of the USSR, but now an independent country. In 2007, Georgia was invaded by Russian forces in 2 provinces, South Ossetia and Abkhazia. And the prosecutor has requested formal approval by the pre-trial chamber to open an investigation into alleged ICC crimes perpetrated by Georgian government forces, by Georgian rebel forces, and also by Russian government forces. That's if the pre-trial chamber approves the opening of a formal investigation, that will be the first time that the court has had jurisdiction over the nationals of a non-state party, Russia, without UN Security Council referral. Now, some people will see that as hugely controversial and others will applaud it because of the very argument that you're raising in asking the question. Because finally the ICC is demonstrating that it's prepared to deal with some of the bigger powers in the world who are allegedly responsible for ICC crimes. If Russia is prepared to investigate those allegations itself and to undertake a bona fide investigation which may or may not lead to prosecution, okay, the court no longer has jurisdiction. If as a consequence of getting formal approval to open an investigation, that acts as a catalyst for Russia to take more seriously its national obligations in respect of exercise of jurisdiction, fantastic. The court will have made a great contribution. That's how I'd respond. I hope that's good for you, Kevin.
Thank you.
Thanks very much. Is no one else brave enough to step up to the microphone?
I've got a question for you.
I'm sure you have.
Yeah.
Professor Jensen.
So let's just assume these facts are true. Let's just assume that in Guantanamo there is at least one person who, for whatever reasons, the government does not have sufficient evidence to try them under the Military Commissions Act of 2009.
Yeah.
But this person is very open about the fact that they believe they were a member of an armed force known as Al-Qaeda, and that when they get the chance, if they are ever released, they will return to whatever battlefield exists where fellow fighters are fighting the United States. How would you recommend the United States proceed with that individual?
I'm happy for that individual to be detained. I want them detained consistently with prohibitions on mistreatment in detention. But the fact of detention, I don't have a problem with that in those circumstances. And if they are to be tried for alleged acts of, well, we're assuming for the purpose of the discussion there is no evidence to be able to try them. But if there is, then I've said what I want about minimum sort of standards in terms of trial process. I'm not opposed to detention for those who represent a threat if they are free to go. But they have to be treated a certain way, and some of the interrogation practices that have been utilised down there in the past weren't consistent with those standards. I'm really grateful that the US has improved its detention treatment practices, and I think the ICRC also is highly relieved about that.
All right, I got one real quick.
You just go to the mic so we can record it. I mean, you could project your voice for me to hear it, but it's about the recording. Thanks.
Sounds good. So I guess my question would be, you've systematically laid out basically the cons to the system that was going forward and what you'd like to see. But you, in certain circumstances, there's at least the positive that would be, under exigent circumstances, torture or this coercion could save the lives of many other people. I just wonder if you'd be willing to recognize that, or if you'd recognize that would be one of the things we're giving up by going to your system.
Yeah, sure. Thanks. It's a good question, but my response is that this sort of ticking bomb theory, proponents of torture in limited circumstances would argue that you're really prepared to say that in those circumstances where this individual is the person with the information that, if we can discover, will result in the protection of a whole stack of lives, that you wouldn't be prepared to do whatever it took to get that information out of them. And as soon as you concede that, then of course you have accepted that in certain circumstances torture is permissible. I think the problem with the ticking bomb theory is that it very rarely works. Well, I mean, I don't know that it ever works, but I can't say that it never does. But it's a slippery slope to say, okay, in certain circumstances, it's okay, it's permissible, and then we see in the state practice of 120 countries, I think, Amnesty alleges the abuse of that exception. So I'm really concerned about that, and I would probably be, well, I won't equivocate, I'll state what I think. It's wrong of me not to mention pros of military commissions, and I should have done that. I think one of them is the ease of being able to establish a proceeding which could be held in situ outside of the US. Military commissions were used post-World War II out in the theatres in Germany and in Japan and in the Philippines and a lot of other locations. There's a very significant pro of using military commissions as a forum for conducting trials. So to have created the impression that I only think about the cons is, I think, a valid response, because that's what I talked about exclusively, but I certainly can see that there are some pros, and one of the reasons for acknowledging that I'm not opposed to military commissions per se is because I can see that there are some arguments for their utilisation as long as there are certain qualifications about rules of evidence and procedure in particular. But on the mistreatment of detainee or the abuse of detainees, I guess I am prepared to argue that one of the things we ought to be giving up is the possibility of extracting information that might lead to the saving of lives by insisting on not engaging in those practices. I think there's a very interesting divergence of opinions between some of your own government agencies. The FBI, for example, understands that whatever practices it uses in relation to its suspects have to be able to stand up in criminal proceedings, and so they won't ever engage in the sorts of practices that we've seen permitted in military detention facilities in Guantanamo Bay and elsewhere, for that very reason, because we have to be able to adduce evidence in the criminal trial proceedings that is admissible and isn't tainted by the way in which it was extracted. I'm with them, I think. I mean, I'd argue that this is not just about making it admissible in a domestic criminal process or in a military court-martial process, but in any process that meets minimum fair trial standards. It's not just about the pragmatics of that. It's also about a very important issue of principle, and that is the basis on which we distinguish our commitment to the way of life we're seeking to defend and protect from the abject dismissal of that by those who we're engaged in a battle against. Might be enough.
We're out of time. Thanks for your questions, and please join me in thanking Professor McCormack.
Thank you, Corey. Thanks very much.